Good morning. I'm Maurice Crespi. I'm managing partner of Schindler's Attorneys, co-founder of COBRA together with IQ Business Group and Engaged Business Turnaround. I'm joined today by a group of panelists from Schindler's, from Engaged Business Turnaround, starting with Grant Hallowell. He's from Engaged. Ian Fleming, he too is from Engaged. He's a business rescue practitioner. Dean Wright, he's my partner at Schindler's Attorneys. He will be focusing quite a bit on the various relief funds and how those funds apply with specific emphasis to the question of foreign nationals. Then we have Pierre van der Merwe. He's my partner. He heads up the Labour Department at Schindler's Attorneys. And Peter Gordon, who is a business rescue practitioner, and he's part of the Engaged Business Turnaround group. The format of today, well, as you know, it's a webinar, so the idea is that you ask questions as we go along. That's what makes a webinar a good webinar, is when questions are asked and we can address them as we go along. Otherwise, it would be quite easy for us to simply pre-record a webinar like this and just play it on a daily basis. So please, we encourage questions. They can either be industry specific or they can be specific to your particular business. You can ask those questions anonymously, or if you believe that you want more specific advice, COBRA is about giving that advice. We can set up private Zoom sessions with you and your team to deal with any specific issues that you may have. COBRA is not about business rescue, believe it or not. COBRA is about keeping businesses out of rescue, and the idea is to create an ecosystem which allows businesses to say to their creditors and to say to their employees that they've entered the COBRA environment to avoid a business rescue. Now, in terms of our Companies Act, in terms of Section 1297 of our Companies Act, it's necessary to put a company into business rescue, or at least to put the vote. The directors have to put business rescue to the vote if they believe that the company is financially distressed. Financially distressed is a low threshold. It's essentially if you reasonably believe that there's a likelihood that you'll not be able to meet your liabilities, your debts as and when they fall due in the ensuing 6 months, that's it. So most businesses at the moment are in financial distress, which means that the board has that obligation to put business rescue to the vote. And if you decline and the board says we're not putting it to the vote, you can quite easily say as a justification to employees, to creditors, that it's because you're in the COBRA environment. Once in the COBRA environment, the idea is for the professional mediators, turnaround experts, consultants to assist in mediating arrangements with your creditors, and inviting them to enter into the COBRA environment so as to have them agree for us to negotiate with their creditors in turn. So it goes all the way up the supply chain, all the way to the bank. And if we can strike those arrangements by addressing the needs, interests, and concerns at each level, we can keep all the businesses out of business rescue. And that's the idea. So that's the idea behind COBRA. There's the services that are offered on a pro bono basis. They're all set out at on our website. The website's www.cobra.org.za. So before we get to the funds and to the specific questions in relation to foreign nationals, we're going to kick off by giving an outline in relation to the legal landscape, the statutory landscape. When it comes to businesses in distress, the various provisions, not only covering business rescue, that can be of assistance, so we'll cover that. So just to kick off, what I'll do is I'll ask Peter Gordon to give us a brief outline of the business rescue process. But bear in mind that we want to avoid business rescue. Business rescue in the COBRA environment will only become necessary if a creditor becomes unreasonable and starts threatening to sue. You'll hear about the moratorium from Peter. So in those circumstances, COBRA will put the business into business rescue to level the playing fields, to get that disparity of bargaining power equalized. So that's the idea of COBRA, and that's the idea of business rescue. There are other instances where it's advisable to go into business rescue, and we'll cover those as well. So outside of pressure from a creditor. Peter, over to you. Thank you.
Maurice, thank you, and good morning, everybody, and a special welcome to all those members of the various chambers that have joined us this morning, in the Italian, Spanish, Belgian, and Swiss chambers, the chambers themselves and their members, so welcome. Maurice, yes, business rescue, Chapter 6 of the Companies Act. It's very clear the whole purpose of business rescue in terms of the Companies Act is to do exactly that, rescue the business. As you mentioned, it requires a resolution of directors, the majority of the directors to approve a resolution stating that the company is financially distressed, defined as the company's unable to pay its, or likely to be unable to pay its debts as and when they fall due within the next 6 months, or within that period, the liabilities of the assets fairly valued are likely to exceed the assets fairly valued. Fairly valued being quite important there. It is fairly valued and not necessarily as reflected on the balance sheet of the company at the time. Once the company has taken that resolution, what is required is the directors have to file a sworn affidavit. The important part of that affidavit, it doesn't have to be particularly lengthy. It needs to state that the company is financially distressed. Importantly, that the directors believe that the company can be rescued. So there is light at the end of the tunnel, and they believe if given the moratorium that you spoke about earlier, Maurice, will allow them the breathing space in order to pull this company through. If that is present, they file the resolution and sworn affidavit at Companies House. There's also a form to fill in, and the company's immediately in rescue. The mere act of sending the email to SUPC is in effect the company going into rescue. As of that date, we talk about drawing a line in the sand. All the liabilities of the company as at that date are frozen. Everything's put in moratorium. Nobody can take action against the company for the recovery of that debt. And when we say nobody can take action, we include in that any legal action against the company, obviously excluding criminal acts. The directors can still be held liable for criminal acts, notwithstanding the rescue. So that now the company's in rescue, that immediately gives it the breathing space, because those creditors that would have been paid under normal terms and conditions in the next 30 or 60 days no longer have to be paid. They do have to, however, be settled in terms of a business rescue plan. Within 3 days of going into rescue, the company is obliged to appoint a business rescue practitioner or practitioners. That individual then takes essentially supervisory control with, importantly, full fiduciary duties vis-a-vis the company, and essentially now runs the company. And the important point here is the practitioner, and it's certainly the approach, and Ian, who's on the call today, and I do a lot together, is to take a business approach to these things. This is not a purely legal issue. It's business as usual, with the proviso that it is governed by Chapter 6 of the Companies Act. So once that practitioner is appointed, he then has to call a meeting of all what we call affected parties, essentially the creditors, employees, and shareholders, advise them of the rescue. Nothing much more, more in that first meeting, but importantly, the rescue practitioner in that first meeting has to state that he too, or she too, believes that this company can be rescued. And that is an important statement that the practitioner is obligated to make throughout the period of the rescue. The reason being that the Act allows for the rescue be defined in 2 different ways. Either the company is handed back, a solvent, sustainable company is handed back to the owners, and it comes out of rescue at that date. Or if that's not possible, the rescue practitioner is allowed to do what we call a controlled wind down of the assets of the business, that is selling off the assets and paying the proceeds to creditors. The important point there is that the practitioner must ensure that at any time the dividend that is likely to be paid to the creditors of the company will exceed that would have been paid were the company to go into liquidation. Not a very difficult target to beat, but that is something that the practitioner's got to keep in mind. If he fails that test, or if the test is failed, then he's obligated to put the company into liquidation. He's obligated to put a plan together. We work with the directors and management of the company on the principle that they know far more about the business than we do. The practitioner then puts that plan together. He has to publish it within 30 days. He can get an extension, but the timeline is 30 days after his appointment. He publishes it, and within 10 days of publishing it, calls a meeting called a Section 151 meeting of the creditors and a separate meeting of the staff to vote on the plan. And the issue on the voting is the creditors who attend by way of person or proxy have a vote in the plan, and of those that vote, importantly, only those that vote, those that don't turn up to the meeting and elect not to exercise their vote, are then carried with the majority that voted, or the group that voted, not necessarily the majority, and are obligated to abide by the plan that has been adopted. The creditors vote. The practitioner needs 75% to say yes, of which 50% of those voting have to be independent. And independent is defined as no previous relationship with the company. So, for example, a shareholder that's given a loan to the company, a director who's loaned to the company, etc., and their immediate connected family are classed as non-independent. And the non-independent vote is diluted essentially by a third. Once it's voted through, the plan then becomes almost the Bible of the company, and the practitioner's obligated to implement the plan as stated in the plan. That could include a compromise with creditors, i.e. creditors are agreeing to take less for their claim than the actual claim, 50 cents in the rand or whatever. If there's minor changes as we go, because as I said earlier, this is business as usual. So any minor changes, the practitioner can undertake those changes without having to go back to creditors each time for a vote. But if there's a major change in the plan, we thought we were going to hand back a healthy company to the creditors, but we've realized we have to do a controlled wind down, then he would go back to the creditors for a confirmatory vote on the change in the plan. In that situation, it would require 50% plus one creditor to vote positively. Once the plan is what we call substantially complete, the practitioner is then allowed to take it out of rescue and hand it back to the owners. And the important word there is substantial, because what you often have, this is, as I say, just normal business, these often loose ends that have to be tied up. And as long as the practitioner puts something in place to make sure that those loose ends are attended to, he's allowed to hand it back to the owners. If it fails, either because people vote against the plan, there is a process where the practitioner can put forward an amended plan or a new plan, or if he fails to do so, the creditors can actually put a plan forward. If all of that fails, then the company is no longer in rescue and by default goes into liquidation. Alternatively, if he's trying to implement the plan and it fails for whatever reason, and he's required to put it into liquidation, there's no debate about that. If at the point at which the practitioner decides this company cannot be rescued, he is obligated to do an application to court for the liquidation of the company. Reece, I think that's it. If I've missed anything.
No, I think you've covered it. Thank you for that, Peter. Just on the question of a liquidation, I think it's important for the various chambers to be aware that in the event of any of the members or any of the businesses coming into the COBRA ecosystem at this point, and the business turnaround, the business rescue does not work, the conversion of a business rescue into a liquidation will be handled by COBRA at no charge. Now, that is a High Court application. It costs in the region of 30 to 50,000 rands. So immediately there's a benefit that can be given, or you could advise your members of this because it's quite a saving. The idea behind it is if a business, if it doesn't survive, who's going to fund that High Court application? Invariably, it would be the shareholders. And that's the last thing they'd want to pay for at that point in time. So it's covered by COBRA. Now, I mentioned that COBRA is not about business rescue, so let's explore some statutory alternatives to business rescue. There's a section 155 of the Companies Act that I'll ask Ian to take us through. Ian?
Thank you, Maurice, and welcome to all the audience members. Yes, so Section 155 compromise is an alternative to business rescue. I'll quickly explain what it is. It also falls under Chapter 6 of the Companies Act. It is the last section in Chapter 6. And what the Section 155 compromise is really about is allowing a turnaround practitioner to negotiate with creditors in each class of creditors for a specific company in order to reach a compromise whereby a part of their debt will be written off, and in order to get the company back into a solvent position so that the company can move forward and carry on trading from a solvent position. It has certain advantages over business rescue because it's often a lot quicker and it's often a lot cheaper. The disadvantage of it is that it doesn't offer the steel blanket of legal protection that Peter was talking about. So while the practitioner is preparing the Section 155 compromise document or arrangement, an aggressive creditor can come and launch a liquidation application against the company, or it can get a judgment against the company and attach assets, as the case may be. So a Section 155 compromise requires, once it's been drafted by the practitioner, it requires the practitioner to call all the creditors together, the creditors from each class of creditors, into a meeting. The plan is then presented to the creditors, and 75% of the creditors in each category of creditors need to vote in favor of the plan. Or if it only affects one class of creditors, such as, for example, if it only affects employees, which are preferent creditors, then only the employees will need to vote in favor of the plan. 75% of the creditors who vote, same as in business rescue, by value, be it in person or by proxy, is required to approve the plan. So if 75% vote is achieved in each category of creditors that is affected, then the plan is approved. The practitioner then takes it to the court. The court ratifies it, and that becomes a court-stamped document, and thereafter the company and the creditors are bound by that arrangement. I don't think there's anything I've left out. Yeah,
pretty much covers it. Thanks for that. Just to remind the audience, please, to pose questions. Anything, let us address them. We have a panel of experts, and that's the point of this webinar, so please. Just moving on to a take-home, which is quite important for your members, well, to the members, and incidentally, my apologies for not having welcomed all of you at the outset. It wasn't very Italian of me, so my apologies for that. Welcome. So there's certain take-homes when it comes to business rescue, and one of them relates to contracts, because what Peter spoke of is a moratorium in relation to claims. So if somebody lays claim and says they're going to liquidate or they're going to sue the business because they're owed money, let's say a landlord, then the moratorium kicks in relation to claims that had already arisen. Now, when a company goes into business rescue, it's important for the business rescue practitioner to send a notice to the creditors or to the counterparties of agreements, such as a landlord, suspending the agreement. Because if that notice does not go out, the agreement remains in force and the obligations remain in force. So if you were to take an agreement such as a lease agreement, if the business rescue practitioner does not suspend the lease agreement is capable of cancellation, and then an eviction is allowed even though the company is in business rescue. So the take home for the audience is to make sure, if you go outside of COBRA, if you don't utilize COBRA and you use another business rescue practitioner, make sure that that business rescue practitioner is aware of the provision in the Companies Act to suspend contracts, and that you are armed with a list of all your creditors, the counterparties to the agreements with their contact details to give, to hand to the business rescue practitioner, so you can immediately send out those notices if appropriate. Contracts that are not suspended are employment contracts. Employment law in relation to businesses in distress obviously features quite prominently at the moment, because a lot of businesses do not know what to do with the fixed costs of salaries. And we've all heard now of businesses slashing salaries by 25, 50%, 75%. The contracts of employment cannot be suspended in terms of that provision. All rights of employees remain exactly the same whilst in business rescue. So it's not as though business rescue gives the business rescue practitioner a greater right to deal with their employees. Now, when it comes to dealing with employees, the provisions of Section 189 of the Labour Relations Act applies. Section 189 deals with dismissals based on operational requirements. Now, in these circumstances, you may not want to dismiss based on operational requirements. It may merely be a cash flow constraint, an interim cash flow constraint. So you may only want to seek to adjust the salary, let's say, to try and negotiate a variable salary as opposed to a fixed salary, something tied in with turnover, let's say. The provisions of Section 189 that deal with operational requirements apply to a unilateral variation of an employment agreement. How do they apply? What you need to do is you need to consult with their employees. In terms of Section 189, you have to give them a notice, a letter, setting out certain information that is required of you in terms of the section, such as the reasons for the proposed dismissals, the likelihood of re-employment, alternatives that had been considered. And an alternative to retrenchment is the reduction in salary. So what you do is you propose to their employees that they not be retrenched. And in the event of them agreeing to a reduction in salary, then they can avoid retrenchment. And then they can agree to that, but they need to agree to that. If they do not agree, if an employee refuses to agree, then the company is obliged to retrench. Hence why it falls under the provision in the Labour Relations Act dealing with dismissals based on operational requirements. So very, very importantly to the members, any dealings that you have with the staff, make sure that you comply. And if you haven't complied, there are quite a few judgments by the Labour Court that you can procedurally undo whatever mess may have been created inadvertently because you weren't aware, let's say, of the provisions where you'd have to provide it in a notice. So if you have taken steps that concern you, we can set up a private Zoom session with us, with the COBRA Labour experts, and we can quite easily regularize any process that you've embarked on to deal with the staff. And the idea is to be very, very accommodating with the staff, to protect the staff's interest, because by doing so, you in turn protect the company. Now, when it comes to staff, another take-home that we've had, well, there are a lot of questions around it, and it's turned into a take-home, relates to business rescue and loans to companies. What we've had are quite a few businesses saying that despite the situation, despite the fact that they don't have cash, they still want to pay their employees. So the question arises, under what circumstances? How does one raise the money? If you've got the money as a shareholder, you want to pay the employees, you want to help them out, how does one do that? Now, there's the notion of post-commencement finance. I'm going to ask Peter to take us through post-commencement finance. And this is a circumstance where business rescue may be appropriate, even where a creditor is not bashing down on your door. So business rescue may be required here simply from a structuring point of view. And I'll ask Peter to give us more detail. Peter?
Maurice, yes, this is an important point, and it certainly is very relevant at the moment in the hospitality industry. I've had one this very morning about who runs a chain of restaurants, and it was exactly this issue. If you provide funding to a company which is in its normal course, and the company thereafter goes into rescue, or worse still, liquidation, depending on your status of your claim, you are the concurrent creditor, so i.e. unsecured. You could be a preferent creditor, Ian mentioned it earlier, for unpaid wages and salaries, or you could be a secured creditor. Those are the normal waterfall in, and SARS is also, just to mention, a preferent creditor in liquidation. That changes quite dramatically in business rescue. Anybody that provides funding, and Maurice mentioned PCF or post-commencement finance, anybody that provides PCF to a company is immediately preferred. Now, what does that mean? It means that the practitioner is obligated to pay, well, firstly, in terms of the act, his own fees, and the very next payment he has to make is to those people who have provided PCF. So you're preferred over all the other creditors that were caught up in the rescue. Remember, I talked about drawing a line in the sand. So those creditors that are now caught up in the rescue and are only allowed to be repaid in terms of the business rescue plan have to wait until those that have provided PCF are paid. The other important point here, and this applies to shareholders often forget this, but it applies to shareholders who might be in an owner-managed business, as well as banks and anybody else providing funding on a PCF basis. The practitioner is allowed to grant you security. So there's nothing wrong with asking the practitioner that you're prepared to provide PCF, but you wish to get security. Now that security is available to the practitioner, and obviously it's any assets of the company that are currently unencumbered. Might be a mortgage that's already mortgaged to the bank. There's a possibility of taking a second mortgage, obviously with the consent of the bank, or any other assets of the company, the stock, the debtors, motor vehicles, etc., equipment, whatever. As long as it's not already secured to a particular creditor, or if there's available value in the existing security, the practitioner can give the new PCF creditor security over the asset. What does that do? If the company were then to go into liquidation, that security still stands, and obviously subject to, if it's a second mortgage, for example, the bank being paid out first, the PCF creditor gets a second bite of the cherry as regards that particular piece of property. If it's a blanket piece of security over the general current assets, for example, or over the stock or the debtors of the company, then who's ever holding that security in PCF is considered super preferent and gets paid out before the other creditors. So the important point here is, please do not put money into a company that you feel is on the edge, is financially distressed, is unable to pay its creditors as and when they fall due over the next 6 months, has a potential of falling into business rescue, and you're doing the good deed of helping the company through this difficult time. Well, then rather put it into rescue. Notwithstanding the cons and the pros and the cons of business rescue, it is sensible to put it into rescue before, and importantly, before you put more money into the company. Maurice, over to you.
Yes, thanks for that. There's a question that has been posted, and it relates to labor law and international contracts that I just want to address. So when one has regard to, let's say, a secondment arrangement where the employee, for instance, has been seconded from a Swiss company to South Africa, what is important to look at there is the agreement, okay? Because the common law position would be that the employee is employed in South Africa, but the agreement can deal with one often finds provisions to this effect that the law of Switzerland will apply in the jurisdiction of Switzerland. So to answer the question, the laws remain the same in relation to foreign employees in South Africa. If there's a secondment arrangement, one has to look at the contract to see how that is regulated. And again, COBRA can give advice on that. So if you want to set up a time or a specific session in relation to this aspect, please let us know and we'll set it up. So it's back to you, Peter. You're dealing with PCF in the context of labor. Again, another take-home and a question often asked relates to suretyships. So can I ask that you take us through what the position is around the moratorium and suretyships, and then again tie that in with the question of post-commencement finance? Thank you, Peter.
Certainly, Murray, certainly. Important point, and it's a question that Ian and I always ask in the environment of the SMMEs, of owner-managers, what personal sureties have you signed? Now, intriguingly enough, in small businesses or medium businesses, people often forget what they normally remember. They've signed a surety in favor of the bank, but you might have signed a personal guarantee in respect of office equipment or motor vehicles, etc. So it's important, as Marie said, vis-a-vis the employment contracts, it's very important to go through all the contracts. First of all, get a register of all the contracts, which would normally be held in a company anyway, and go through all of those contracts and ascertain two important things amongst others. Are there any personal suretyships in here? And then secondly, is the contract immediately in default because of the act of going into business rescue? Now, in the early days of business rescue, the banks were a little bit slow. They were, however, the fastest out the blocks in amending all their contracts to include business rescue as a default under a contract. Now, if a personal surety has been signed, generally where we are at the moment, because the banks did get their act together, most suretyships will state something along the lines that the company, the holder of the security, has the right to bring action against the person who gave the security, notwithstanding the fact that the company's in rescue. So remember, business rescue is about, and it's in terms of the Companies Act, important, underlined, it's companies, including close corporations, that are in rescue, not the individual. So the individual who's signed surety is still obligated to pay, can still have a demand on them from the aggrieved creditor who's now exercising their security. Important point there is people must have exercised their security. Certainly we talk a lot about landlords' hypothecs over the equipment in the premises, as well as a supply of materials, a reservation of title over stock. Those have to be exercised. And exercise means they have to state, you're not paying us, we now hereby exercise our security, a legal process. If they haven't exercised their security, then they can't do so whilst in rescue, because as I said earlier, you can't bring action against the company. But personal suretyships will still stand. As Maurice was saying with PCF, if you are putting money in after the event, what is not a bad idea to do is, if there are any, and depends on the quantum, I suppose, but if you've got a relatively small or a creditor that you can afford to settle personally, and you're wishing to put money into the company, it's not a bad idea to settle that creditor personally via the company, not directly, but via the company. So what does that mean? It means the company goes into rescue, you make a loan to the company, and please do make sure it's formalized, not just putting money in the bank account, but actually do get a loan agreement drawn up. Agree it with the practitioner, obviously, who has the right to accept or reject the offer of the loan, and then use that money or provide that money on the understanding that the secured creditor will be paid, and the practitioner can make a decision to bring that into the rescue. And if he brings it into the rescue, you're thereby relieved of your obligation under the personal surety, because the creditor's obviously been settled.
Perhaps if I can just weigh in there a little bit, Peter. Yes, we often have situations like that, where during the course of negotiating a business rescue plan, negotiating with creditors, we often do try and negotiate relief for personal sureties of directors and so on via undertakings given to creditors as part of the business rescue plan. It's important to note that most of the banks nowadays have very firm surety arrangements in place as part of their agreements. There was a judgment handed down in 2017 in the case of Newport Finance, which was a lender, and the judge ruled in that case that a business rescue plan can wholly or partially extinguish a primary debt, but business rescue was never intended to assist sureties to extinguish debts in their entirety. So the banks have all built in very, very clever and very strong sureties into all their agreements, but it's very important that we look at the surety agreement, because every surety agreement is typically different. So one of the first things we often do is ask the client to send us the surety agreements that they've signed, so that we can assess them and advise them on the way forward.
Maurice, just sorry to interrupt Ian again there, because Ian's just made another important point. Don't forget, if there's a compromise in the business rescue plan, and let's say it's paying 40 cents in the rand, once it's voted through and adopted, no creditor can come afterwards and say, I didn't vote for the plan, I therefore still have a claim of my additional 60 cents. Can't do. As I said earlier, you are bound by the plan, even if you didn't vote for it. There is a provision in the Act that pulls you along with that. Another important thing, and it's a practical example, we've just dealt with one. The supplier was supplying to a subsidiary company. They took a security, a guarantee out of the parent company, signed by the shareholders of the parent company. And in the parent company were the owners of the business's personal residence, 2 residences. So of course, there was huge risk that this would be sucked into the rescue. However, what they'd done is mortgage those properties and put that money into the subsidiary to keep it going. So they had massive shareholder loans in the business as well. And what we got with the supplier that had the holder of the security, we agreed with them, while we only paid out, I think it was some 30 or 40 cents in the rand, the portion of the 40 cents that was going to go to the 2 shareholders for their loans would be ceded to the supplier. So the supplier essentially got 100 cents in the rand. All the other creditors got 30 cents in the rand. And of course, that was transparent. It was laid out in the plan. And as a result of that, the plan was adopted. We managed to keep the supplier satisfied, to the point that they are an essential supplier. There's only 2 material suppliers in the country. They continued to supply this business with product, and they, over a period of time, going to get paid out in full. And importantly, the supplier also had CGIC cover over their debt, and we negotiated with CGIC that this was an acceptable solution. Failing that, 2 shareholders would lose their personal residences, which I think CGIC even agreed with us would have been unfair. Just a story.
Just to touch on the transparency thing there. Yeah, transparency is a very important part of business rescue. It's something that we uphold at all times, and a lot of people, in the audience might have heard bad business rescue stories, and the fact of the matter is that since the outset of business rescue in 2011, a lot of business rescue practitioners haven't covered themselves in glory in the way that they've acted and the things that they've done, because they've acted without transparency. They've done deals with shareholders and directors without anybody else knowing. They've done deals with creditors with specific creditors without anybody else knowing. So it's we might touch on this later, but it's very, very important to choose the right business rescue practitioner to assist you should your company go into business rescue. Can't remember where I was going with this, but Maurice, over to you.
Yeah, thanks. I'm gonna ask you shortly just to take us through, practically how a business rescue works in relation to the strategy that you employ on costs, variable versus fixed, with particular emphasis on staff. But before I get there, I just want to mention 2 things. Firstly, when it comes to post-commencement finance, COBRA has several partners who provide such finance, and they're within the ecosystem. The benefit that's emerged of the COBRA ecosystem is it's also become a marketplace, and every member has agreed to provide pro bono services, including, let's say, R&B ventures when it comes to post-commencement finance, subject to the means test. They are very happy to provide advice on a pro bono basis. So just bear that in mind. If there is post-commencement finance that's required, there are various options within COBRA. And just to cover something that Peter mentioned, he said that business rescue is for companies and close corporations. I just want to mention that COBRA also assists sole proprietors, business trusts, and partnerships. So if you're not a company, it doesn't matter. Turnaround is turnaround, and the idea is to turn the business around. It doesn't have to be within the statutory context. Moving over to Ian, just to take us through your methodology, Ian.
Certainly, Maurice. So what we do, yeah, I meant to touch on this earlier. What we do from the outset, so typically a company will come to us and say, we've got a crisis, we can't pay our debts, we're in trouble because of COVID-19 or whatever, and we will typically engage with the clients immediately, either on a Zoom telecon or a meeting or a telephone call, where they will tell us exactly what they believe the problem to be, exactly what the causes are of the problem as they believe it to be, and we'll ask them a lot of questions, and they'll tell us all about the history of the company and so on, and what led to the financial distress. What's very important for us then to do is to start assessing. We start building a picture in our minds, exactly what the course of action is going forward for that company. And there's various scenarios we can consider. We have to consider what is in the best interest of the company and its affected persons, being its creditors and shareholders and employees. And we have to keep reassessing throughout the entire process whether we are on the right track with that company. And the various options that exist for us to choose are: is it business as usual for the company with some minor interventions, with some minor credits and negotiations, for example? Is it what we call an informal turnaround, which is a turnaround, a restructuring and turnaround outside of the legal protection of business rescue? We often do that when the creditors are very reasonable, and there's one big key creditor like a bank that we know and we can negotiate with, and they'll treat it as if it's a business rescue, but the company doesn't have the stigma of business rescue attached to it. And that's different to the Section 155 compromise that I spoke about earlier. So we ask ourselves, is it a Section 155 compromise? Also, a Section 155 compromise requires fairly reasonable creditors. You don't want creditors who are aggressive and knocking the door down. Is it a business rescue? Does the company require the protection of the steel blanket that Peter spoke about? Or is it, in the worst case scenario, a liquidation? Obviously, we try to avoid liquidation at all costs. There's no incentive for us whatsoever to put a company into liquidation. We don't act as liquidators ourselves, and it's very, very seldom from the outset that we will choose liquidation as the way forward. It would have to be a company that's seriously rotten from the core or to the core. So throughout the entire process, we're weighing up the different possibilities that exist for us as to the way that the company can go forward. And as part of the COBRA ecosystem, as Maurice calls it, we'll be advising you all the time as to what our thinking process is around what we should be doing with your company, what the next step is, should we carry on with the existing plan of action that is currently in place, and so forth.
Great, yeah, thanks. I'd like to move on to the various relief funds. I'm going to ask Dean to spend some time on taking us through the funds, the implications, but also practically, what have you seen, Dean?
Morning, and morning to all the various chamber members and attendees. Yes, so let's start off with what we have available on the cobra.org.za website. And what we've done is we've got a whole team of researchers, and from our side as well as from the Business IQ side, putting together a mass information bundle, as it were, on the website. And I urge everyone who wants to find out precise information is to go to the cobra.org.za website, and at the bottom of the page, you'll see it says Help Portal and Knowledge Base. If you click on that link, it takes you to a very nice web page that has the various initiatives that have been fully explained under each section. So as we sit, there's about 38 or so initiatives, and it goes all the way down from bank initiatives to telecoms initiatives. And what we did specifically for this this webinar is to try and see if there are any funds or initiatives that only relate to South African entities, or more specifically, if any foreign companies are specifically excluded. And the good news is that whilst a lot of them don't specifically exclude foreign companies, there's only 2 relief funds that do. The rest of them are silented or specifically incorporated, which is a very good thing. And the 2 that are excluded are the Debt Relief Finance Scheme and the Business Growth and Resilience Facilities. Those out of the 40 are the only specifically excluded funds. But in practice, what we have seen a lot of is questions regarding the TERS and UIF applications, as well as the retail sector. We've seen quite a lot of. And I think it's just important to note that in terms of what is needed to make application and be accepted or be granted some of this relief in these funds, is each of the entities has to have its corporate governance and structures in place. And when I say that, I mean to make use of TERS, for example, you have to have been UIF registered prior to COVID. Ideally, what they would have liked to have seen is that all your UIF payments were up to date. We have heard of instances where UIF has entered into acknowledgements of debts to regularize the outstanding UIF payments so that employers could make application on behalf of the employees, and have been successful on that. And so that's just from the UIF perspective. And there's very specifics on how to apply for UIF and through the TERS relief system. And we have been seeing some technical difficulties on that. Some people think it's a rejection, but it seems to be a massive influx that everyone has applied for. And once they have retried and resubmitted with the correct documents, they have been successful. A majority of people we've seen have been successful. And I think that in terms of the tax relief measures, it's very important that in order to make use of these, or to be eligible to be granted these reliefs, is your tax affairs have to be in order. Again, tax compliance, nothing outstanding, negotiations with SARS have to be brought to some type of conclusion to be eligible. So it really comes down to the governance of the entity, regardless of whether it is a South African entity or not, how it's been registered, who it's registered with, what its compliance is for you to make use of these funds. And we have, just also to go back to our website, if you go down to the bottom as well, there's a green button that says request assistance. And I think it's just important to highlight that a lot of our time has been spent creating these information bases, and that request assistance is basically like a little Google. So you can find the information immediately once you've finished, or once you type it in, it'll come up with what you need. And we've highlighted and gone through sort of a step-by-step snapshot of each of those funds and how to make use of them. And if anyone does have further or needs specific information, they're more than welcome to send us an email at info@cobra.org.za, and we can take them and help them through those processes, Bruce.
Yeah, thanks, Dean. I see a comment's been posted. I believe foreign employees are excluded from these benefits. Also, most relief measures are only either for BBEE companies or for 100% SA-owned companies. Can you comment on that?
Sure. So there's, as I said, there's only 2 of the 40 or so initiatives that specifically exclude foreign companies. But in terms of the foreign employees, if they have their work permits and the employer has been registered fully, as I've discussed, they are entitled to those benefits. Obviously, what it seems to be is that, this is unconfirmed, it's just something that we've noticed, is that the South African citizens have been paid quicker than some of the other ones, but as I said, it's completely unconfirmed. We have no confirmation of that, but it does appear that is happening. Again, some of the funds and the relief options do require BE companies, but that's really not a foreign aspect or not. It's a South African aspect, because I mean many companies aren't BE registered themselves. So I think that's quite an important distinction.
I see there's a comment posted. I also have seen most of these initiatives exclude foreigners. Some say the company has to have 75% SA citizens to qualify for these funds. But what you're telling us is that it's not most of the initiatives.
It's not most of the initiatives. Those ones in particular, the debt relief finance scheme has to be 100%. And I'll read it to you right here. But 100% own SA South African citizens or employ at least 70% of South African nationals. And that's the one I'm specifically talking about, and that's the debt relief finance scheme that we know of. As I said, a lot of them have their own requirements, but as a general sort of blanket, we can't really go through 30 or 40 initiatives, but we are willing to, if there's any of those specifics that come up, please engage with us. Let's chat about it. Let's see if we can do and learn more ourselves on it.
Yeah, certainly. I mean, it's a moving target. It's changed practically daily. We hear new initiatives and new issues.
And the amount, I mean, we've, as Schindlers, have prepared sort of a backbone of all this information, and that document in itself is about 70 pages, and we update it on a weekly basis. So it is a moving target, and everyone's still learning what's happening practically on the ground, and we adapt and move as and when we can.
And how does it work? Do you apply once and it's monthly, or do you have to apply every month?
It depends on how your workforce is operating. Obviously, if you have less employees that are able, I'm just talking for TERS specifically, if you have less of a workforce that is able to work or partially work, you would make application as and when. I think Pierre is our partner on this. He deals a lot with these types of applications. Pierre, do you have any comment on that? What have you seen in practice?
Hi, yeah, you would definitely need to make application again because obviously your circumstances may change. So we would suggest making application again for each month or as the different lockdown changes, because you're only able to make application while your business or part of your business has been shut down. So I wouldn't expect the UIF to just keep on paying without a further application from your side. So yeah, I would definitely recommend just putting in additional applications.
Yeah.
Thanks, guys. Moving to another topic, I'm going to ask Peter to deal again with questions that have arisen, and that is that we all know that some businesses are not up to date with their taxes, or they've understated their income. What is the position in relation to business rescue, COBRA, and SARS?
Maurice, yes, it's often a concern of directors who approach us and are deciding whether to go into business rescue or not. Remember what you said earlier, if the company is financially distressed, they are obligated to put it to the vote of the board. But in that process, a lot of deliberations take place. Now, one of them is, we've underdeclared our tax in the past. What's going to happen? It's not unusual in the SMME market, and it's something that we're quite used to dealing with. If the company is in business rescue, importantly in business rescue, then the practitioner has investigative rights and is in fact obligated to investigate the affairs of the company. If the practitioner finds any wrongdoing, so anything that has been done that contravenes any act, the practitioner is required to report that to the authorities firstly, and then to instruct management to rectify what was done, and further to instruct them to desist from continuing to do so, whatever they might be doing. So now you have a situation, a company's underdeclared its tax, whether that's VAT, PAYE, or corporation tax. What the practitioner and what we do is, strangely enough, the act is not clear on who the authorities are that this should be reported to, but obviously if it's a SARS issue, we would report it to SARS. And what we found is that and Ian often makes this point, SARS are not there to put companies into liquidation. SARS are there to try and preserve jobs, firstly. Well, not firstly. Secondly, SARS are there to collect tax. And by putting a company into liquidation, they've just lost the taxpayer. So it's not something that they would necessarily be the driver of. So a discussion with SARS, a full disclosure of under-declaration. Obviously, there might be penalties and interest to be paid. But in a negotiation with SARS, what we often find, especially where we're talking about a compromise, that SARS often get paid the amount that they would have got, had everything been properly declared in the first place. So it is a negotiation. We do have a relationship with SARS that they are prepared to have these discussions with us. Sometimes if they are totally non-trusting of the company, it becomes a bit more difficult, but we do persevere on that. Other issues of under-declaration or illegal acts, remember I said in the beginning, if we find that there's been an illegal act, so the company's defrauded, the directors have defrauded somebody, then that has to be reported to whichever authority, in a general case to the police. But if there's if the company falls under a regulatory authority, such as it's an FSP falling under in other words, a financial service provider falling under what is called the FSCA Act authority, rather previously the FSB, then we would report that to that authority, and they then have to take their own investigative actions against the directors of the company. But yeah, SARS is normally somebody that we would work with if they owed money and if it's been underdeclared. So it's not a major issue. It is obviously a normal thing in smaller businesses where people have either inadvertently underpaid or found that they chose to underpay tax, and we work with it rather than against it.
Right, we're running out of time, and there's quite a bit that we haven't covered. We have daily lectures. We have another one tomorrow at 10 o'clock, which covers these issues, these topics. So what I'd ask is, because we're out of time today, if you could join tomorrow or any other day, because we will go through some important topics, just to mention to you what those topics are. We'll be dealing with the duties of directors during a business rescue process, the qualifications of business rescue practitioners and what you can do if they misbehave, the plan and how a business rescue plan works, the voting, insurance. Let me just pause on insurance. That's quite an important one. We've had insurance specific webinars, but let me mention to the audience that we're looking at quite a few policies, and the businesses are insured. They are insured, but the insurance companies are saying that they aren't. So what we're doing is we're putting together, in effect, a class action per policy, so that we can assist the businesses in recovering those amounts. And that could be the business rescue plan in itself. So it's conceivable that a business rescue practitioner will say, we will instruct attorneys to recover the amounts, let's say on a contingency basis or a pro bono basis if the means test is struck, and we'll recover those amounts, and that's the business rescue plan. Once the amounts are recovered, creditors can then be paid. Costs of business rescue, how liquidation works, and other ancillary topics. So if you can join for those, or go to the COBRA website and have a look at the targeted webinars that are coming up. We have webinars dealing with the aviation industry, specific to, we're also dealing with landlords, the hospitality industry. And what we've also done is we've set up specific webinars for companies. So we had a construction company approach us and asked that we have a webinar for their suppliers. They wanted to take care of their suppliers, which is quite unique, and have their suppliers enter into the COBRA ecosystem. So we can do that as well for you and your company and your staff. So let's just have a look if there are any further questions. I don't see any. So I think I'm going to conclude by thanking the panelists for their assistance today. Thank you, Grant, Ian, Pierre, Peter, and Warren. And most importantly, I'd like to thank all the chambers for participating today. That's the Italian, the Spanish, the Belgian, and the Swiss. Thanks for today. Please bear in mind that we can host these as often as you like. And if you want us to deal with specific industries, we will. And we will make the recording available. It will be on the site. So go to www.cobra.org.za and everything will be there. Thank you so much for your time, and I hope to hear from you all or see you at tomorrow's webinar. Thank you then. Bye-bye.
Thank you.
Thanks, guys.
Cheers.